Hi everybody, this is Adam Brown, A Brown ESQ LLC. We are discussing a new case, our appellate corner, where I talk about cases and try to break them down to you. Now, Happy New Year. I review, just as a review, I review family cases. They're unpublished. You can't cite them in court and rely on them for precedent. I find these cases interesting, and so pretty much watch some of the other videos, you'll get a gist of what's going on. But getting right into it, this first case that came down, it was decided December 29th, 2023, C.B. versus K.S. This is a Middlesex County case. And, this isn't really the most interesting case. Right out the bat, this is a restraining order case. So we all know how restraining orders go, but if you don't know how it goes, it's an analysis that's done under the case of Silver versus Silver. They have to look as to whether there's a predicate act. They have to consider the prior history of domestic violence between the parties. Question I get a lot: Can people include things from the past? Is there statute of limitations on things that they can talk about in the restraining order? The answer is twofold. First, absolutely they can include things from the past. It could be from 10, 20 years ago. They can put it in there. Oh, he punched me in the face when we were at prom night. That's in. They can put all that stuff in there in the past. The only caveat is that if it's not in there, you can't talk about it. So someone could have very well punched you dead in the face, and if it's not included inside of the four corners of the restraining order, you can't talk about it. It violates the other person's due process, which is why the judges ask you, are you ready to go to trial? Do you want to amend? Do you want a lawyer? 1,000,000 times, because they're not going to let you talk about it. Now, practically speaking, a lot of case law advises that there needs to be an adjournment, and they're liberally granted. But these cases, again, are emergency cases. They're done ex parte initially. They need to be done within 10 days per AOC guidelines, I think. So it has to be very fast, the point is. So you're not going to get 1,000,000 times to try to amend the complaint. All right, so here we go. You got to figure out the predicate act. You got to figure out the history, if there's a history of domestic violence. It's not mandatory that there's a history, but they consider the history. And the last thing you have to analyze is if there is a need for the restraining order. What does that mean? So a need for the restraining. Actually, let's work forward. First thing, predicate act. What does predicate act mean? You'll notice on your temporary restraining order different boxes. They're different criminal offenses, harassment, assault, etc. All of that is in the restraining order, and whatever is alleged to have been done on that day, that would be the predicate act. So you have to prove that something happened that day. Now, it doesn't have to be a history. In this particular case, the judge granted the final restraining order and made findings as to findings of fact, conclusions of law, as we say, as to why there was a predicate act. No problem. But the problem the Appellate Division had with this was that the prong regarding the whether the restraining order is necessary wasn't really fleshed out enough on the record. There's a specific statute here, NJSA 2C:25-29, A1 to 29A6, and those are different factors the judge should consider if the restraining order is necessary. That includes, do they have kids together, what are their relationships, what are their financial ties with one another. They're basically trying to see if you're going to be around each other, if you have reason to. Is it necessary to do this? Most of the time, my experience, that's kind of an easy thing to prove, that it's necessary. This case, frankly, the judge said, the Appellate Division said that the judge's analysis was incomplete. They couldn't give meaningful review. The judge did go through the predicate act, said there was harassment, they said the judge made general findings, but no findings as to whether it was necessary. Now, I've had these go a couple of different ways because for some reason it feels like a few years ago, this was the main thing that people would appeal out of restraining orders. It felt like every opinion that came down, they said it's reversed and remanded because the judge didn't make the findings if it were necessary. And after a while, it became like a broken record. And I haven't seen one of these in a little while come down from the appellate division that the judge didn't find the necessary, because it's so simple to find whether it's necessary. I think in this case there was a relationship, there's a kid, like it's so simple. So like, and the reality of the situation is that, it's being remanded, and it was like this, what happens on remand is it's this little trivial analysis by the judge that says, well, I think it's necessary because one of those factors, and that's it, and then maybe they can go into a little bit, but there was times where judges they don't expressly have to go through each factor one by one. It can be gleaned from things they're saying. They kind of broaden the analysis, but I guess in this case they weren't satisfied, and that's how it could crumble.